Hi everyone. Today I wanted to talk about what happens when your US citizen child turns 21 and what that means for immigration. My name is Ruby Powers and I'm a board certified immigration attorney with Powers Law Group. I'm a the firm is 14 years old. I wrote a book about law practice management. I teach law practice management, small business, and we've been helping individuals with family, employment, investment, humanitarian, immigration court, all immigration you can imagine. We're located in Houston, but we have global reach with U.S. immigration matters. So this is a hot topic because I see often, so often, that people come to our firm on the day of their child's 21st birthday, or a couple days after, or a couple days before, and I have to explain to them this process. And it's really heartbreaking because if you don't have it just right, you might not be eligible. So that's why you have to pay attention to this. And this does not take the place of legal advice. This is just information, and definitely have a consultation with an experienced immigration attorney. You can call us, you can find someone else, but basically, I just want you to know this because this is a common misconception. So let's just talk about what being an immediate relative is for immigration purposes. So your immediate relative, if you are the spouse of a US citizen, you're the unmarried child under 21 of a US citizen, or, and this is the big one, so I highlighted it, enlarged it, the parent of a US citizen if the US citizen is 21 years of age or older. And so that's generally what we're talking about. So let's say an individual came into the United States, and this is where it gets down to, there's two different ways this could shake out. Let's say they came in legally on a tourist visa, on a student visa, on an E2 visa, I don't know, something type of visa that allows them to adjust in status in the United States. Even if they're not in status at that moment, but their child is 21 and up, US citizen, and they don't have any other inadmissibilities. Of course, there's a lot of little things I have to caveat, explain out, but for the most part, this could potentially work, and that you could have your child, who's now grown up, petition for you, and do it all together in an adjustment of status and get your green card, legal permanent residency in the United States. Now, but the biggest thing that's important about all of that, and there's lots of big ones, but one of them is that you had a legal entry or an exception to that. We'll go over that pretty soon. Other thing to note is that you came in, if you overstayed, that you didn't leave and come back in illegally or something like that, because that gets really complicated and very likely not eligible for something. So, a clean case we're talking about is you entered legally and then your child turned 21, US citizen, boom, we can do that. As long as you don't have like lies to the government, misrepresentation, fraud, crimes, deportations, other things like that. Now, the other scenario is you're outside of the country, and your child's now 21, wants to petition for you. Well, if you don't have any other inadmissibilities, which are keywords for problems with immigration has problems with you, then this could also be an option. But where this really gets tricky is if the person entered illegally and they don't have one of the alternatives to that legal entry. So let me walk you through what that means. So when we're talking about a legal entry, they probably entered on maybe a B1 or B2, a tourist visa, a visa laissez, maybe they came in on a border crossing card. They had a legal entry with a potentially an I-94, a stamp, and a passport. The other thing could be a parole. They were paroled, and there's document of that. And the other might be option could be the military parole in place. This is when you have a spouse or a child in the military, ready reserves, has one of those types of things, and qualifies for military parole in place. Then if you apply for that, you're eligible, then you can get what's called a parole, and that's good for 1 year at a time. That parole, you could then adjust status and act as a qualification for adjustment of status. Now, I might be getting really technical here, so I'll try not to, but a lot of times people have a general idea and then they start researching more specific information. And I want to be a resource, but you also might just need to have a consultation to get that specific answer to your question. So what we're talking about with all of this admitted, inspected, or paroled type of conversation, it's because we're talking about INA 245A. And so we want to be able to explain that you're qualified for that. The other thing to note when we talk about the legal entry is like you want to have proof of it. So some people might not have the proof. And when we're talking about, like, let's say an I-94, we need to get proof of, you can also do a form called an I-102 if you need to try to find proof of it. Or you just need to do some Freedom of Information Act requests. Or maybe you could write off an affidavit explaining that you did enter legally. But the more you can exhaust your remedies to prove that you entered legally, the better. Okay, so let's say you don't have a legal entry. Well, let's think about some other things. Maybe you had DACA, okay, and you had DACA and you're eligible for the advanced parole on DACA, and you're able to get that travel permission to leave, come back in, you get a legal entry, and then you have a U.S. citizen child who's 21 and up, and this is quite possible because the oldest DACA recipient at the time of this recording is about 42. So it is possible for a DACA recipient to have a 21-year-old. And so that might be another option. And so then I would say that's in our legal entry options there. The other thing could maybe consider is 245I. So we're talking about the Immigration Nationality Act. So 245I is a provision that says, I'll paraphrase basically, that if you had a I-130, an I-140, or a labor certification filed by April 30th, 2001, that was approvable when filed, if you pay a $1,000 fine, that would count. I just try to explain it like it's like a legal entry. It sort of waives that problem that you entered illegally. And so we're using INA 245I instead of 245A, like over here. And so this could be an option as well. So that's why when people come in, I ask, did anybody petition for your mom or dad? Aunts, uncles, tell me, talk to me, grandparents, who's does? We do a deep dive, we play detective, we try to figure it out. The other thing that could possibly be is maybe you're not eligible for adjustment of status with your child's petition, but maybe you're eligible for a provisional waiver. You would need to have a U.S. citizen or legal permanent resident spouse or parent or U.S. citizen fiance to be a qualifying relative. So that means your child could maybe help with the first petition, the I-130, but they wouldn't be able to help you with the waiver part. The other thing that could be is maybe your cancellation of removal, and we just put 42B for shorthand, but that means you're in court and you have 10 years or more in the U.S. and you have good moral character and extreme and unusual hardship to U.S. citizen, legal permanent resident, spouse, parent, or child. So you can list the child in that one, but you have to be in immigration court. The other possibility is that there's a U visa, and a U visa waives almost everything, pretty much everything, almost. But the thing is, they're taking about 15 years right now. But if you entered illegally, you have deportation, you false claim citizenship, it'll waive it. And then we also like to put reform in there when we're trying to be optimistic. So now, other things to note, whether or not, so let's go back and remember what we said between the adjustment of status versus consular processing. In either case, you're still being screened by USCIS or Department of State for any inadmissibilities. We talked about that, right? So inadmissibilities, it could be criminal matters like I-601. It actually would help waive criminal matters. Multiple entries, there might not be a waiver for that. We have to evaluate removals. I-212 can help you in some cases. It doesn't help for in absentia, and you need to watch for those. And then also it could be alien smuggling, which means like if you helped your child come into the country and they think you aided, abetted, assisted, and blah, 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 they could charge you with alien smuggling, and that would require an I-601 for that. So you need to be screened for all other possibility inadmissibilities. I will say, and not to scare you, but I will say that this is a good administration. This is a good time to try to get these things done. There's just a little bit more discretion right now. Not saying everything's easy. I'm not saying that at all. I'm just saying like there's just things are moving a little bit faster and things are there's a little bit more consideration. And so, but I also trying to lay this out to explain all the different things you have to think about. So don't just think because your child turned 21, it's all solved. You have to have had a legal entry or one of the equivalents or an exception. And if not, then we have to explore those other options. We also have to evaluate inadmissibilities. So this was just a quick little video about webinar about what to consider. Um, and please feel free to share this. We put this in English and Spanish, and we also have more programs for the rest of the month, including about lesser known immigration alternatives, which could be good if you're not eligible for a petition right now. The other to explore that. The other thing is work authorizations and asylum clock, and then non-immigrant employment-based visas. So we're a full service immigration law firm with several attorneys. We speak multiple languages from Spanish, English, Russian, Ukrainian. We have assistants who speak French and Turkish. I sometimes speak some French and Turkish. But anyway, please give us a call if you have any questions. We're available at 713-589-2085. We send a newsletter in Spanish, Spanish, Turkish, and English every other week. And our website's rubypowerslaw.com. We're on TikTok, Facebook, Twitter, or X, I guess it's called, LinkedIn. I don't know, we haven't gotten on Threads yet, Instagram, and you can also reach us on this QR code. So hope you're all doing well, and we'll see you next time. Thanks for watching. And please feel free to share this with anyone you think that would benefit from it, a friend, a neighbor, help explain and have a consultation. We need a more thorough understanding of